Now, I'm going to say that on top of, I said all that up front because this thing got pushed forward into a real formalized, I won't say formal, but formalized process almost immediately before the parties engaged in any kind of process that bankruptcy judges always encourage. And that is the informal production, the informal request, which can be done by a letter from counsel to counsel. And then it's sort of expected in the prevailing local culture of bankruptcy practice that the respondent gets their client to produce everything that they can informally. The idea being that that's a lot less costly and it's a lot more professional. And then, if there's some suspicion that it's not complete, then you get formal. That's the way it's done to respond to the fact that nobody involved in a bankruptcy case has unlimited funding to spend a lot of time rattling around in the formalities when it's not necessary. So that's why, by and large, the real pros in our bar, the specialists, the ones who really do bankruptcy full-time, have those understandings between them, and the court encourages that because we see a lot less of foolish disputes like the one that's at bar. Because this is foolish as it has been styled and presented from the perspective of both parties. So, that's why I'm denying the motion, and it's not because I'm reaching the merits of the demand. It's not necessary at this point, and it's not warranted. I'm not going to spend any more time on it than I'm spending on this hearing this morning at this point in this matter, because I'm going to make Mr. Labor go back and do it the right way if he thinks he's entitled to all of this production. And Mr. Turback, your client, is going to have to respond in the right way, under oath, accounting, if that's demanded as part of the request for production of documents, accounting for the inability to produce things. And if there is some objection based upon this theory that we're dealing with separate business entities and my client may not have been in control of them or whatever, then objection can be made with specificity, and if you have a dispute over whether that's discoverable, bearing in mind the fact that I basically consider everything way out to the boundaries to be discoverable. I mean, that's sort of what the rules say. It doesn't have to be capable of being introduced into evidence, just likely to lead to the discovery of admissible evidence. But if you then have issues, then you can get them framed up after a conference and presented to me. Obviously, that's a lot of work. And frankly, we set it up that way under the local rules to make sure it was, so that maybe parties would just get reasonable and there'd be a level of trust. Doesn't seem to be an awful lot of trust as between these two parties. And that may hamper lawyers in trusting one another or trusting what their clients want or trusting what the opponent produces or the position the opponent is taking as a party. And therefore, the two of you may have to continue to be fairly unbending with each other. Okay, if it gets to that, fine. I'll deal with it when the time comes, and I'll get to the bottom of who the sticking point is, and they'll answer for that. But the way this came forward is so anomalous, is so odd, and is just so inappropriate at this point. There's no way I'm going to grant this motion. It's entirely without prejudice to the discovery process going forward from here. I am pursuant to Section 107C1A and Rule 9037A1 also going to order Mr. Labor to take the steps necessary to submit redacted documents not containing any information within the scope of Section 107C1A. And that basically refers to, quote, any means of identification as defined in Section 1028D of Title 18, contained in a paper filed or to be filed in the case under this title. So you then go over to the Federal Criminal Code. Congress incorporated by reference a roster of documents containing means of personal identification into that bar on the submission in an original document. So, Mr. Laver, you're going to have some reading to do here, and you're going to have to review line by line everything that came in under those attachments. I'm sure you thought you were framing up the dispute pretty well, but right in on his coattails came stuff that cannot be in a record before this court. So you're going to have to submit modified versions of those images, and you're going to have to work with our system staff to see that those are substituted pursuant to my order. And you're going to do that right away. And you're going to review that stuff line by line, because when I reviewed this motion at a little greater length, it must have been last Wednesday, Thursday, in between everything else that was going on last week, first thing I saw was, income tax returns, because the obligation to submit Social Security numbers in full on the face of the return, and so I winced, and then I saw, corporate returns, and I'm still not sure whether the corporate tax ID number is subject to that example of means of identification. You're going to look at that, and you're going to redact for that if that's included within that. I think Congress's concern was more personal information than corporate information, but who knows? So that, maybe that's okay, but then I thought, I'm just going to take a skim down here, and sure enough, I toggled on down, scrolled on down, found a schedule with an individual Social Security number. And I didn't even look over it line by line. Not my job. Now it's yours. So that's the order I'm going to issue here in disposition of this motion. Denied without prejudice, but to any further effort to compel discovery properly styled up under the Federal Rules of Bankruptcy Procedure.
Your Honor, may I ask a question? Given that the motion has been denied, is it logical that maybe what we do is remove the image of the tax returns so that Mr. Turbuck and I can sit down and we can say, what do we need? How do we need to do this? And if we remove it altogether, then we, of course, would be in compliance, but it gives us a chance to start over and do it right, and I apologize, but it just seems a logical thing to remove it altogether.
It's never removed altogether. We will suppress the image. I don't know if that's appropriate under the circumstances, because quite frankly, for the purposes of any review in the future by some appellate court or whatever, I can access suppressed images. I mean, I've sort of looked at them trying to get prepared for this hearing. And the images that were suppressed are apparently just the scanned images that were scanned from word processing produced text. But frankly, you're going to have to do about the same thing. And I'm going to make you go through the effort. So, no. Number one, we can't just remove the images. I could suppress them. But frankly, I want the record out there, accessible, for instance, by Mr. Turbuck in the future, too, because if I suppress the image, he's not going to be able to access it in the future. And it's already a matter of public record. It's just it has to be redacted to delete the non-public information on it. So answer to that is no. You're going to go through and you're going to be, you can go ahead and use a real dark magic marker if you wish, and that's probably a better way than even using the Adobe tools, because depending upon your version of Adobe, sometimes that stuff that you use a blackout Adobe tool on actually ends up being visible in ghostly format, something we discovered to some horror some years back. Adobe apparently corrected that.
I'll use a black magic marker.
So